feel low, you can still go. Even when you feel slow, you can still go. Even when there's no hope, you can still go. I never answer to no, man, I still go.
We are in for a massive treat. QueenBee's lawyer has responded to Bullhorn Betty's last filings to the court. Just a reminder, I am not a lawyer and I do not claim to be one. Today I am going to be going over QueenBee's lawyer's filing objections to request for telephonic virtual hearings.
Objections to request for telephonic/virtual hearings August 17, 2023. QueenBee, through counsel at law office, responds to Bullhorn Betty's request for telephonic/virtual hearings, request, as follows. Introduction. Betty's sole basis to avoid appearing at this court, where she sued Queen, is cost. The request should be denied. In major part, it should be denied because it would deny Queen the right to cross-examine Betty at an evidentiary hearing on Betty's motion for protective order. Motion for protective order against QueenBee August 15, 2023. Relevant factual and procedural history. Betty sued Queen June 13, 2023. Her complaint alleges that she suffered business losses due to Queen's critical commentary about her. Generally, Betty obtains revenue by providing commentary and so-called reporting on tragedies. Generally, thus, this is a business dispute at least in part. Once Queen defended herself, filing counterclaims and seeking a bill of particulars, Betty lashed out. She filed a motion for a protective order, which necessitates an evidentiary hearing. She moved to dismiss the counterclaims. And, in part escalating her vitriol against undersigned as well as Queen, Betty filed a meritless motion to strike Queen's notice and demand for a bill of particulars. In sum, Betty filed a lawsuit here, in Knox County, Illinois, over a business dispute, and has created the need for not only hearings, but evidentiary hearings. Governing law. The Ninth Circuit Administrative Order No. 2023-2003 governs Betty's request. It amended the Ninth Judicial Circuit Court Rules, Local Rules. Local Rule 1.80 was amended to provide the court with discretion to allow remote hearings to address, among other things, cost or time savings. Local Rules, Part 1.80. Nothing in the rule mandates remote proceedings, and the court may require in-person hearings if the judge determines the nature of the hearing, the conduct of the parties or attorneys in the case, or the need to allow parties and their attorneys to communicate and negotiate effectively requires it. Evidentiary hearings cannot be held remotely. Argument. The entirety of the reason for participating remotely is set forth in a single sentence. Betty resides in redacted city, redacted county, redacted state, and travel to hearings would create a financial hardship. Request for telephonic/virtual hearings, page 1. This court cannot grant the request as to the hearing on the motion for protective order. And as for the hearing on the remaining motions, the court should exercise its discretion to deny the request. First, Betty seeks a protective order, which requires an evidentiary hearing. Queen intends to cross-examine Betty and establish Betty is not entitled to a stalking no-contact order. Evidentiary hearings are exempted from remote hearings. Local Rules, Part 1.80. In any event, given the nature of the hearing, this court has the discretion to deny the request based on the nature of the hearing requiring appropriate cross-examination. Betty's public persona, correspondence, and filings indicate a combative individual with a degree of legal skills. An in-person cross-examination is necessary for Queen to protect her procedural due process rights, especially in a case involving a SNCO. Second, it makes little sense for the court to require an in-person hearing for one motion when others are stacked at the same time. Efficiency dictates simply hearing all motions at once. Third, Betty refuses to speak with undersigned counsel. Exhibit 1. While she has since said she will if Queen caves to Betty's demands, which would require Queen to stipulate to a violation of the local rules, Exhibit 2, the current status is that Betty will only speak to undersigned in filings or at court. But, now she does not want to attend proceedings. The court should exercise its discretion to facilitate the communication and any potential negotiations between undersigned and Betty. See, Local Rule, Part 1.80. Fourth, the basis for the request simply appears to be disingenuous. This is a business dispute by Betty. She chose to file suit here. And now she wants to avoid financial hardship by not visiting Knox County, Illinois. Just days before filing her request, Betty explained she was as part of what constitutes her business visit Idaho, potentially South Carolina or New York, and leaving the following week for a surprise, undisclosed, location. Exhibit 3. So, Betty can, and does, travel for business throughout the country. She can certainly travel for her business suit. Conclusion. Betty's request should be denied. It is simply not allowed for one of the pending motions and the others are noticed up for the same time. Even if that were not the case, the court should exercise its discretion to require in-person hearings, at least for the pending motions. Respectfully submitted, QueenBee, by QueenBee's lawyer. Notice of filing and certificate of service. Undersigned certifies and states this document was filed on August 17, 2023 using the court's Odyssey e-filing system. He further certifies and states it was served by electronic mail to the persons below on the same day, Bullhorn Betty and Heels in the Air signed QueenBee's lawyer. Exhibit 1, from Bullhorn Betty to QueenBee's lawyer.
Mr. Lawyer, your professionalism is disgusting. My concern would not be a lawsuit filed against you, but rather a complaint. I am almost certain you compare my channel and what I've said to your client. My case is in good standing. I understand the elements, I've expressed the elements in my complaint, and provided the evidence to support those proper and legitimate claims. If you were going to write me to continue to harass me on her behalf, you've got a big problem, and I'd be more concerned about other more formal repercussions than I would be a lawsuit from me. I'm unsure what your client has told you about me, but I will not allow you to continue her harassment upon me through emails because you're her attorney. Furthermore, if this level of harassment continues from your office, I will be filing your demand letter in the court for the judge to take judicial notice of. Now, if you would like to speak to me and address me with some professionalism, I am happy to work with you on this matter as I am opposing counsel by way of me representing myself. Again, I have stated legitimate claims and I have met the elements of those claims. And since it appears that you do not wish to work with me, I'm going to demand that you discontinue communication with me until we are before the judge to discuss this very matter. Respectfully yours, Bullhorn Betty.
July 20, 2023 at 11:23 a.m., QueenBee's lawyer to Bullhorn Betty.
Ms. Betty, I received your email. While I disagree with your conclusions, we note your intention to persist and will proceed accordingly. As for my letter, and to prevent a misunderstanding causing you to file another suit, please note that under Illinois law, defamation requires publication to a third party. Even if the letter's contents were untrue, and were not subject to the litigation privilege, then it still was sent only to you. Thus, there is no basis for a claim. Signed, QueenBee's lawyer.
From Bullhorn Betty to QueenBee's lawyer.
Dear Mr. Lawyer, first, I found your demand letter very insulting and lacking great facts. Second, I find it hard to believe an attorney would initially try and intimidate me through a demand letter. Your information is very much incorrect. There have been 2 lawsuits, both of which I prevailed on. I don't take the act of suing someone lightly. I have repeatedly told her to stop. She continues to lie about me. Even your demand letter is defaming and untrue. Have her give you all those lawsuits I've filed. No, I will not drop the lawsuit. Have a great day. Respectfully yours, Bullhorn Betty. July 18, 2023 4:23 p.m.
Exhibit 2, from QueenBee's lawyer to Bullhorn Betty. August 15, 2023 10:55 a.m.
Ms. Betty, as you seek to hold up the regular advancement of a case through communications to your demands that you be allowed to proceed telephonically, we will stand by your prior directive to not communicate outside filings. Signed, QueenBee's lawyer.
From Bullhorn Betty to QueenBee's lawyer. August 15, 2023 10:49 a.m.
Dear Mr. Lawyer, to reiterate, if your office wishes to stipulate on those 2 items, I will be open to such discussions. Respectfully, Bullhorn Betty.
From QueenBee's lawyer to Bullhorn Betty.
Ms. Betty, received. Your bar on communication complicates how to proceed, but we will proceed as best we can without further communications. Signed, QueenBee's lawyer.
From Bullhorn Betty to QueenBee's lawyer. August 15, 2023 3:09 a.m.
Dear Mr. Lawyer, please find attached the following documents for the above referenced matter. 1. Motion to dismiss counterclaims. 2. Motion to strike bill of particulars. 3. Objection to discovery requests. 4. Motion for protective order. 5. Notice of filing affidavit in support of motion for protective order. 6. Request for telephonic hearing. 7. Plaintiff's first request for production of documents. 8. Notice of filing certificate of service for plaintiff's first request for production of documents. Please let me know if you have any questions. If your office would like to stipulate to dismiss this action against Ms. Co-Defendant and the notice for telephonic hearings, please let me know. I apologize, but I am new to the Odyssey system and didn't realize until this morning that the motion to voluntarily dismiss was in their system, but I inadvertently didn't submit and it has been in draft status this entire time. It was successfully uploaded this morning. Respectfully, Bullhorn Betty.
Exhibit 3 undersigned certifies and states that 1. I am an attorney, over the age of 18, and otherwise competent to make this affidavit. 2. On August 16, 2023, I watched a video on the YouTube platform, resolved by visiting the URL. 3. That video was titled Saying Hi, was posted on the Bullhorn Betty YouTube channel, and featured a woman I recognized to be Bullhorn Betty based on her resemblance to media coverage of Ms. Betty. 4. During her video, Betty stated that being out in the field was her working, stating, about a shirt she was wearing, "This is gonna pretty much be my uniform out in the field whenever I'm out working." 5. Betty went on to say she has been dealing with a lot of deadlines, presumably about the case in which I represent QueenBee. 6. Betty goes on to state, then, we'll be out in the field. We've got several trips already planned. We're going to Idaho by the end of the month. We're going to try to get over and do some coverage. I'm not sure if we're going to do it in South Carolina or New York for Rex Hoyerman. Plus, we're going to be leaving next week. I'm not going to tell you where we're going next week, but we're going to go out and try to bring awareness to a case. 7. If called to testify to the foregoing, I would competently and truthfully do so. Under penalties as provided by law pursuant to Section 1 to 109 of the Code of Civil Procedure, the undersigned certifies that the statements set forth in this instrument are true and correct, except as to matters therein stated to be on information and belief, and as to such matters the undersigned certifies as aforesaid that he verily believes the same to be true. Signed, QueenBee's lawyer.
This is one of many responses from Queen's lawyer, and each one is better than the last. Let me know your thoughts in the comments section below.